Hello, my name is Dave Zapponi, and I am the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you all for participating in today's webinar. ECHO is a statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and networking. Thank you for coming today. Today's event, we have a few housekeeping items, and Connor's going to put those on the screen. These are now presented on your screen. In addition, slides were sent to registered attendees prior to today's webinar. Please take a moment and review our housekeeping items. The chat icon is to be used to report technical issues and to communicate directly with other participants in the webinar or the speakers. You can place your questions in the Q&A feature, and that's where we'll take a look at those and answer them along the way. I will try to answer some of the questions during the presentations, or we may answer all of the questions during the Q&A period at the end of the webinar. I think Mark's going to take a few questions during his presentation as well and take a look at the chat as we go. Questions about specific situations are better asked of the attorney serving your association or another appropriate industry expert familiar with your specific situation. Now, let me direct your attention to your monitors, where you will find our disclaimer. None of what is said during this seminar shall be construed as specific legal or expert advice from the speaker, sponsor, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you. And now, a bit about today's speaker. Mark Guthius, Esquire, is the founder of Community Legal Advisors Incorporated, which represents more than 500 HOA communities in California. His firm provides assessment, collection, and general counsel services. For more than 20 years, Mark has provided general counsel and civil litigation services to the firm's community association clients. Mark also serves on the ECHO Board of Directors. So thank you so much for coming today, Mark, and putting the program together. Go ahead and take it away. It's all yours.
Thanks, David. It was important to get started on this right away. We were caught off guard by it. To be sure, there was a statute going through the legislature which had similar language to what became the law here. We were in negotiations as an industry through ECHO and CAI and CACM, some industry groups, to get that language changed. And initial conversations with the author indicated that the language could be changed. We were able to show examples of why differing fines in differing communities made sense. And so we had thought that this was kind of back in the bottle. But what happened was the legislature needed to pass its funding and its annual budget. And for some reason, AB-130, which is the funding bill, included language that capped HOA fines at $100 and added a few more hoops for the boards to jump through when imposing those fines. And so we're gonna go through that protocol. But the real takeaway from this first slide is because funding the government is effective immediately, this isn't a situation where the law suddenly takes effect or doesn't suddenly. It's a situation where normally we have laws. When new laws come through, they're January of the next year. And so we have 6 months to train the industry, to get the industry ready for what's coming. But this is the law today. This is the law as of a week ago. And so it was really important to me to reach out to Dave and to get this sort of presentation together. So let's move to the next topic. Let's talk about okay, so there's some lag on that. Let me get back to where we were. Let's talk about how we normally use a fine, how we normally advise associations to use fines. Normally, we advise associations use fines as a get people's attention situation. Is a income tool, it has some real problems. So the idea that we're just going to fine people and pick up a few $1,000 for the association's budget isn't the way to do it. Moreover, we've seen over the decades of practicing law in this area that imposing serial fines of the same amount don't really seem to get the attention of the people. They just seem to think, oh, well, we're just getting fined. Screw them. They have to collect it, whatever. And so really, we've been a big advocate of kind of one fine, maximum two fines, and then move on to the next step. And we'll talk about what those steps are. So the question is, what can this fine be? And it's a little more subtle than just saying that it has to be limited at $100, because there are certainly situations where we can fine more, and there's certainly situations where we're not going to use a fine at all. So, for example, if you have a board member who's getting harassed by an owner, we might go directly to a temporary restraining order. We might go directly to a lawsuit. So there are areas where a fine isn't appropriate at all. But let's play the game here. What we're looking at is really a regurgitation of the statute as revised. So 5850 as revised by this new law. The association must distribute a copy of the fine schedule to each owner as part of the annual policy statement. Remember, this is generally the Thanksgiving Day package that goes out to all owners and gives them all the information about next year, what the budget's going to be, and that type of thing. The association needs to distribute a copy of the fine schedule as part of that. That has been California law. That's not new. If the association passes a new fine or schedule since sending the annual policy statement, that must be communicated to each owner via mail. That hasn't changed either. That is California law. So the new one, a fine shall not exceed the lesser of the monetary penalty set forth in the fine policy. So if you have a $350 fine for doing something, or $100 per violation. So obviously, in some cases, that's going to take that 350 down to 100. There's a lot of discussion, and we're going to get to it. I saw the first question that hit the chat was, how are we defining violations? And let's understand that what you see here, $100 per violation, is what the statute says. I need to be very clear about this, because everything that I'm going to say is forward as to what is a violation is subject to a judge interpreting this. I'm going to tell you what I think it is. I'm going to tell you what I think you can do with it, but you need to understand that a judge may come and disagree with me. I'm also going to tell you what most of the industry experts in our industry are saying, which is to say that all of us attorneys have a chat and we talk back and forth about new laws. We talk about you. We talk about what's going on in the industry. So we've been talking about this very language, and you're not going to like the fact that most of the attorneys are agreeing that a violation is pretty much the event, the general description of the event. So we're going to get to that. So what is the exception, Mark? When can we unquestionably go beyond $100? When can we default to that $350 fine that's in our existing fine schedule? And the answer is, if a violation may result or safety impact. You see the quotes. This is straight out of the code. May result in an adverse health or safety impact on the common area or another association member's property, and the board makes a written finding to that effect. So if we're going to default to the $350 fine that's in the statute, or in our fine schedule, we're going to have to show that it has an adverse or creates an adverse health or safety impact. And we're going to talk about how that is defined as well, because I think those are the two hot questions. And for that reason, I put them really first. But we need to hit the statute first so you understand what we're playing with. We're playing with this language. And so you say, Mark, what is meant by violation? And the answer is, it says violation. It doesn't say a violation as defined as A, B, C, and D. Well, what is an adverse health and safety impact? I'll go one more on that. I think the legislature hasn't defined adverse health and safety impact because they don't want to limit it. And so there is no definition of that. So there's gray area. Anytime there's gray area, people are going to disagree. We're going to have some different opinions. So we'll talk generally about where the industry thinks that's falling. So if the board makes that finding, if that's the case, then in that case, the full amount of fine as identified in the fine schedule or your CC&Rs can be imposed. Okay, so it's not only $100 all the time, but maybe it's $100. And that's interesting. So now we're last provision of 5850, no late charge or interest can be charged on a fine. So this is interesting because sometimes associations want to add that fine to the assessment collection invoice. And sometimes when the owner pays the assessment but doesn't pay the fine, they're suddenly charged a late charge. And what I want to make clear straight up is that that late charge can't be attributable to the fine. If somebody pays their assessments late, late charge is fine. But if somebody doesn't pay their assessment late, but they get a late charge because of that fine, that's invalid and will be reversed by a judge. Okay, so then we get into subsection F, which is really Civil Code 5855. When sending a notice of hearing, the board must include a copy of the fine schedule. It must be sent a notice of the board's undertaking that discussion about whether they're going to fine needs to be sent to the owner at least 10 days prior to that hearing. It must include a time, date, etc. The hearing, describe board is and the right to move to executive session at the request of the owner. Then notice of the board's findings are mailed to the owner within 15 days of the hearing. Now, this is important. That second deadline is important. I train my managers when I do HOA manager training. I make them repeat to me the mantra, every hearing is held at 10:15. Every hearing is held at 10:15. I make them repeat it back to me. Okay, so what am I trying to imprint? I'm trying to imprint the idea that we need to give at least 10 days notice. This is straight out of the corporation's code. We need to give at least 10 days notice before, then we hold the hearing, and we need to give 15 days. We need to let the people know what happened at the hearing within 15 days of the hearing. So let's move from there. I just want you to understand these are the things, the steps that the legislature expects us to affect when we're. So practically speaking, how is this going to affect us? The answer is it's going to have an effect, and this is a difficult thing, and we'll get to fines being reasonable. One of the statutes says that fines must be reasonable. Maybe I read past it. But the reality is that that's always been California law. Always has been California law that a fine has to be reasonable. And let me start out of the picture there for a second. The fine has to be reasonable, and this is already in play, which is let's say that we're in a community where the houses are, 75 to $250,000, right? Maybe a mobile home community, maybe, something like that. Those fines, 25, 50, 100, that's going to probably be found reasonable by a court. On the other hand, the Three Arch Bay, $10,000 per day for violating the architectural regulations. Didn't really get the attention of the owner until the association got up to about $125,000. Then the owner sued the association, said those fines are unreasonable. Court upheld the fines. Court upheld the fines, saying, "Hey, pretty clear that property owners. So this is reasonable." And so I think that we need to look at the fact that we've had this kind of provision in place. Fines have been a useful tool. But that's not going to be the case, right? Practically speaking, escalating fines to resolve legal conflicts short of ADR or IDR, then legal action, has been wiped out, right? It's a useful tool to resolve common enforcement issues, but we're going to have to explain, we're going to have to take a look at each fine and make a determination. Is this a health and safety issue? Does it affect the common area or another owner's property? If so, we can default to the full value of the fine schedule. If not, we're going to have a limitation to that $100. Okay. Can we impose daily or weekly fines? Here we are. This is the one of the two big issues, and I put it right here 10 minutes into the presentation or so because I know it's the hottest issue, guys. And the answer back is you saw the language. Maybe. I mean, the statute limits the fine to $100 per violation. And as an attorney, I'm happy to go into court and argue that a fine is a reoccurring thing and it occurs each day. And I think there's better arguments for certain things. Like, for example, somebody parks in the common area parking. They're not supposed to park overnight, but they park each night. And I think each time they leave, I think that we begin to get an argument that this is a reoccurring violation. It's multiple violations. Now, that argument could be voiced either way, and a court could find either way. We can get all the way through it, and a court say, it's all the same violation, counsel, and the statute limits me to $100. And we're stopped. So how much money do you want to spend to try to collect a $100 fine, right? So we're gonna go through the answer. I have to be fair with you. Most of the attorneys in the industry are either bifurcating the fines, meaning that, okay, well, if the issue stops and then starts again, stops and then starts again, some attorneys are saying, okay, that's a different violation each time if it's so stated in the rules and regulations. Okay. Many attorneys are saying, no, parking in the common area is a violation, and this guy's done it 35 times. And so the question as a practitioner comes, how are we going to handle that? How are we going to advise the association? And I think if the association is going into small claims to collect those debts, I think it's pretty easy to tell them, go ahead and accrue those violation, but each its own with its own new notice, hearing, and letter of violation assessment, right? The 10-15 rule. Okay. If you're going into Superior Court, I'm not so sure, because when we get into Superior Court, there's a thing called prevailing parties fees. And if I go in and I say, look, it's $100 a day, Your Honor, for 90 days if the person didn't trim this hedge. And the court looks at it and says, hey, man, the whole issue was the hedge wasn't trimmed. It didn't reoccur each day. It wasn't a new violation every day. People weren't woken up and shocked by it every day. So we're gonna award you $100. We're not gonna award your $9,000. Well, then who's the prevailing party? I'm going to argue the association's the prevailing party because maybe the thing got trimmed. But you know, that owner might come back and say, hey, I just walked away from $9,700 in fines, Judge. I'm the prevailing party. I just paid $100 and I'm out of this. And I think there's going to be some parlay, and the association could be on the hook for some of the owner's legal fees. In which case the owner could the owner could win and the association could lose from a financial point of view. And so we're, as an industry, the attorneys are being pretty conservative here, and you need to understand why. So again, if your association moves to collect fines in small claims courts, I think you can be much more liberal about what is a new violation each day versus maybe what a judge might say, well, that's the same violation. It's just recurring, right? Okay, so this is a risk proposition, and we just need to be thinking about how it want to vary from client to client and how those clients prefer to access the courts as to how you want to play your fine schedule. Okay. I promise I am going to look at the chat, but I'm pretty sure the chat is asking me questions that I'm covering right now. And I want to share that information in one train of thought before we start getting into random examples. So, no, does this destroy our enforcement process? I mean, did we just get screwed out of our enforcement process? And the answer is no. Remember, our enforcement processes usually start with a standard courtesy notice. Hey, Mr. Zapponi, you left your trash cans out. That's a violation of Rule 16. Please take your trash cans in. That standard courtesy notice isn't changing. Maybe in the next month you say, hey, Mr. Zapponi, you did that twice, and we're now calling you to a $100 fine because it's recurring, it's a violation, and we need to get your attention on this. And that's going to be fine. What you're not going to do, maybe, is go to a third, fourth, fifth, sixth scenario on that. So, what are your alternatives? Well, your alternatives haven't changed. At the point that the fine schedule stops working, you simply roll into IDR, ADR, and a lawsuit. So let's remember that we're not entirely wiped out here. We still have the situation where there is a health safety issue that we can go over $100. We still have our full enforcement panoply of tools. We just don't necessarily have fines over $100 if it's not a health safety issue. Okay. Um, I know I'm forgetting something, but we'll move to the next. Here's kind of the same, here's kind of the other issue. And this is where we've spent the other 30%, 40% of our time kind of debating on the internet with our fellow attorneys is what is an adverse health and safety impact? And the answer is that the legislature has not defined adverse health and safety impact. So it's kind of in the eye of the beholder, which doesn't free you to make up anything you want. But if you can come up with a reasonable basis for why that might be a health and safety issue, then I do think it's fair to hit for your full value of your schedule. So I'm going to talk in generalities here. However, one of the people attending the seminar email that really went through like 30 different examples, and they were just fun. We were cracking up playing with them. So I'm going to go through those just a little more in depth, but let's just talk in vague generalities. Some violations are plainly not health and safety issues. If you think about it, I have two owners. One has, I mean, they're both Newport Coast overlooking the water. Houses are in excess of $10 million. And one guy is growing bushes that's blocking the other guy's view. And we were doing doubling fines. That was our approach to the situation, was doubling fines. Clearly, this is now gone, right? So some violations are plainly not health and safety issues. Most aesthetic violations, maybe an improper tenant registration, failure to submit architectural applications, other forms, these aren't health and safety issues, right? So they're going to fall under the $100 thing. I think if you have noise issues, if you have pet violations, if you have smoking violations, maybe we get into nuisance and safety violations, people parking in a red zone. I think those are, and I think that you can fine for your full value. A closer call is when we get into things like short-term rental violations. This is a disaster for the desert. The communities that have fines, which are equivalent to a couple of days rental, for the music festivals, are really now in a tough spot because now they've got to wait until the house is used incorrectly and then sue. And that's how are we going to set a value for that now? So this is a real boondoggle for that community. health and, is a rental violation a health and safety violation? Is it, likely they can't be unless there's some component of actual disturbance of other people, and then how much of the disturbance is a health and safety issue. I'm going to roll over to that email because I think this is the right place for it. It's oh great. I'm just gonna go through some of the examples that an owner sent over. Says, what about discharging a BB gun into a neighbor's window? I think that's an easy health and safety, and I think preventing a neighbor from exiting their garage by commanding a child to stand in front of the path of the vehicle, easy, right? Blocking normal flow of traffic, positioning an occupied vehicle in the middle of the road. Yeah, I mean, again, if it's going to get hit, it's a health safety issue. Using a vehicle as a weapon, yeah, sure. Parking in a fire lane. Again, I used that earlier, and I think it is. Leaving pet feces in the common area. I think you're going to have a hard time collecting on that. I think that you're going to have a hard time convincing a judge that's a health and safety issues. I think the best way to do it is that you're going to talk to your landscaper who probably charges you a premium to clean up dog poop. And they're going to say, gosh, we need to bring people in with gloves and toxic whatevers, and you can build a case. But I think, you know what, you better be ready to build that case if you want to collect the fine. um, Allowing pets off leash. Okay. I mean, this is going to be very subjective, right? If I let my 8-pound poodle off the leash and she barks at you, is that a health and safety issue? What if I let my 130-pound pit bull killer off the leash? These are different things. Feeding coyotes and feral cats and otherwise encouraging and emboldening the presence of wild animals, I think that could be a health safety issue. It's because it seems like those animals might come in and bite people, more likely who are moving around the common area. Threatening violence in the pool area. I don't know if that's a health and safety issue. Climbing a fence in and out of the pool area, maybe. You see where I'm going here? I hope you're seeing these aren't black and white answers because the statute is obtuse. The statute is just what you've read. And we're all reading the same thing, saying, well, we can construct arguments in some situations, but we can't construct arguments in other situations. And that's really the purpose of this. Really, the purpose of this is to say the statute, the purpose of the statute says, look, the board of directors has to make that decision. They have to make that finding. They have to hold a hearing. They have to talk to the owner, and they have to make a determination of whether it's a health and safety issue. So they're going to make a determination whether it's a $350 fine or a $100 fine. So how would the board make that finding? Well, it's supposed to, the statutes was originally worded poorly and is now worded poorly, still worded poorly. Basically, they want you to have the hearing in an open session. And I'm going to talk about that. If the owner here it comes in, I want you to go to executive session immediately. If for some reason you want to stay in open session, I think for liability purposes, when we're talking about a violation, make sure nobody else is in the room. This is a hearing. You should be in executive session. And I think we sort of ignore the language of the statute as it pertains to the owner's option to have an executive session or not. I think we just try to go into executive session. But we need to come up with written findings. The board needs to come up with written findings as to why they believe the greater fine should occur. And if these things find their way, if this action finds its way to court, a judge is going to get into those findings. And for that reason, we think that when you're holding these hearings, unless it's pretty clear, we think you should have an attorney involved writing those findings so that you're ready to defend them or protect them in court. Um, so I think that's the way it's going to happen. You're going to hold that 10-15 hearing that I was talking about, and you're going to have the board make a decision, and you're going to bring the person in, and you're going to have a conversation. My experience, if you can get the person to show up for $100, is that if they show up for a fine, the problem usually resolves. And so there's great value in holding the hearing. Um, After that, you're going to ask for IDR, I'm guessing, and they may or may not show up for that. After that, you're going to serve them with a request for ADR. But the board's going to have to determine if they really want to spend some real money on enforcing an action when I see you appeared, David. Am I already at my hour?
No, you're not, but what I'd like you to do is to explain what IDR and ADR are, what they
Okay.
mean in implications, because we got a question about that.
Bunch of questions on that. IDR and ADR are essentially different forms of alternative dispute resolution. Internal IDR dispute resolution is done just with the board and the owner. And it's often a precursor. I suggest it's a precursor any chance you get before going into ADR, because if you can solve the problem without a neutral, without some a mediator or arbitrator there, it's going to charge you 4 or 5 thousand bucks to be there. Then I highly suggest that you do it at the internal or informal level. The ADR is alternative dispute resolution, and it's using a arbitrator, mediator, a professional third party neutral, as they're known in the industry, and we utilize them to help try to resolve the matter prior to litigation. And it's a great thing to have a retired judge or an attorney who's sitting there and gives the other party a clear idea maybe about how he or she perceives the situation. Which is to say, I've had a judge sit down with my client and say, look, I think you're absolutely out of line. And I've had them sit down with opposing counsel's clients and say the same thing. Matters can resolve, and that's a lot better than litigating if you can. So, obviously, and the title of the course is that we're going to have to look at changing our fine schedules, and not all attorneys have talked about how they're going to handle this. So I will tell you what our firm is doing. Our firm has come up with basically an overlay. You're simply going to add it as an addenda on the face. Our clients are going to add it as an addenda on the face of their rules and regulations pursuant to the civil code. And essentially, it's going to lay out what the new law is without changing what the existing rules and regulations really are. There will be value in having us review the existing rules and regulations. I find that about 20% of the time, rules and regulations violate the Fair Housing Act. There's usually some mention of children and how toys and discriminatory language about the distinction between parents and adults and the use of the pools and the hot tubs and that kind of stuff. And when we start requiring different things of different people based on their class of age, race, color, creed, etc., we run afoul of the Fair Housing Act. And so I find that quite often rules and regulations are rife with this. So what we're going to do is offer this addenda to our client. We're going to review the rules and regulations, and we're going to look for problems or violations. We have debated back and forth whether or not we should interlineate within their existing rules and regulations or architectural standards. Remember, it applies to this too. Um, Whether we should talk about why each issue, predetermine why each issue, or whether each issue is a health and safety matter. And we've concluded that the better route is to let the board do it. I think if the board believes and can hold up their right hand in front of a judge and say, hey, we originated that, we think it's a health and safety issue because of A, B, and C, it's a lot better than saying, well, because our schedule says so. So we're staying out of that business at this time until somebody else convinces us that we should. So let's talk about what our addendum looks like, and so basically it's just titled addendum to fine and enforcement policy. I said that, and the first paragraph is the following is added to and to the extent of a conflict shall supersede any existing rules and regulations and any separately published enforcement or fine policy in accordance with California. And I cite the sections of the civil code so the courts know why we're doing it. Now, one of the questions that seems to arise is, Mark, we're revising our rules and regulations. Do we have to go through the 28-day process of new rules and regulations? And the answer is no, because what we're doing here is purely statutory. Now, if you get into the rules and regulations and you find that, hey, it's time to modify the rules and regulations anyway, like I said, you find some fair housing issues and that kind of stuff, my inclination would be to go through the 28-day process. Doesn't cost you anything. It's a little more of a process, but if you're just making changes pursuant to the Civil Code 5850 and 5855, then I don't see the need for a change. Okay, so this is kind of how we are attacking this wicket. So fines, monetary penalties shall generally be divided into three categories. Fines which are unlikely to result in an adverse health and safety impact on the common area or another member's property. Those are minor violations. I'm defining them. Those don't exist in the statute. I'm just trying to give them a definition moving forward so that we can say that minor violations receive the $100 fine. So just trying to set it out. Fines B, fines which could result in an adverse health or safety impact on the common area or another member's property. Remember, the statute says we can charge the full value of that fine. We're going to define those as major violations. You can call them what you want. Again, and then C, fines which are monetary charges imposed to reimburse the association for costs incurred by the association in the repair of damage to the common areas and facilities caused by a member or the member's guest, is a reimbursement assessment. So why is that in there at all? I feel like we need to define it because in 5850 is discussion of the reimbursement assessment. Within the Civil Code 5850 is discussion. And so if we're I don't want a judge to conflate it. I want to be very clear that we're not limited to $100 when we're repairing common area damage. So I just laid it right out in the schedule. I just said it's a reimbursement assessment, something completely different. All right, so there, no surprise. The fine for minor violations shall not exceed $100 violations, $100 per violation, and the fines for major violations may be in the amount published in the association's governing documents. You've got a CC&R, you've got a architectural regulation, you've got a rule and regulation, or any separately published enforcement or fine policy if the violation could result in an adverse health or safety impact on the common area or another member's of property. In such case, the board shall first make a written finding specifying the adverse impact. Now, listen, don't be sucker punched by the first make. You can make that at the hearing. The board can have the hearing with the owner and make a determination of whether they think it is while they're voting to approve the fine, whatever the fine is. So don't worry about that. When I initially looked at that, I thought, oh, so they have to decide up front. But then later on in the statute, we see that the board shall make that decision at the meeting. So the fines are monetary. I'm just going down the paragraphs that I have on this addenda that I put on the front of their rules and regulations. Fines or monetary charges for reimbursement and assessment shall be in the full amount of the association's out-of-pocket expense to repair the damage. I mean, let's be clear on what this is. It's if the member cures the minor or major violation prior to the hearing, the board may not impose a fine. If the member provides a financial commitment to cure the violation, the board may not impose a fine. And then I said, for reasons of insurance and warranty, members may not effect repairs to the common area and facilities. Because obviously, if the member repairs the common area facilities and does a substandard job, contractor who works on the common area, we don't want the owner working on the common area injured, suing the association, that sort of thing. So, um, there are times when the board may not impose a fine, and it has to do with people repair or fix the situation. And I think this is, this kind of goes to taking the trash cans in, right? Well, wait a minute. The violation occurred. Just because they took the trash can back in, we can't impose a fine? Maybe. The violation occurred. The person parked overnight in the common area parking. Just because they moved their car, does that mean that we cannot fine. Well, I mean, I think we've got able to, I mean, I cannot find, we can find $100. But I think there you're going to look at per instance and how we want to do that. If the board meets, okay, so here we are. We're going to have this hearing. The board's going to make a decision. The board meets to consider a fine. The board shall notify the member in writing, time, date, place of the meeting, 10 days prior, which notice shall be delivered to the member. Meetings to discuss the fines shall be held in executive session. And I should add, Lori, if you're listening, add that it needs to be communicated to the owner within 15 days. And then if the board and member reach agreement during such meeting, the board shall draft a written resolution. The resolution signed by the board and the members, which is not in conflict with the law of the governing the documents, is binding on the association and judicially enforceable. So be aware of that. If you make a compromise in a meeting, make sure that the compromise that you make is consistent with the association's governing documents. If the board imposes a fine on the member, the board shall provide the member written notification. Oh, here it is, of the decision by either personal or individual delivery within 14 days. And the board and member are not in agreement after such meeting, the member may request IDR and the board may request IDR under 5910. So those are, oh, no late charge or interest can be charged. And the association shall provide a copy of the most recently distributed fine schedules upon request, and honestly, when you send out the fine. So I'm going to go to the questions and answers now, but I think you've got a pretty good overview of the situation. Dave, what are your thoughts here as I scroll through the mini chats?
Well, take a look at the Q&A. The chats questions should not be placed in the chat, so just look at the Q&A. What I'm going to
Only
ask the
30 of them,
members,
Dave.
what I'm going to ask the members to do is to look at the questions and put your questions in the Q&A. And then vote. There's a little thumbs up icon in the corner, in the bottom left corner, and vote for the questions that you would like to have answered first, and then that'll prioritize our Mark's time, and then we will sort by the number of upvotes, number of thumbs up, and Mark in the on the right hand side of your screen for the
Yeah.
in the Q&A, you'll see it says most recent.
Oh, yeah.
Hit the little down caret there, the arrow, and,
Most upvotes.
and it'll go most upvotes. So go to the most upvotes and we'll take the top ones. Okay.
Okay.
And
What about fines? What
you're going
about,
to need, Mark, before we go on, you're going to need to refresh that every once in a while as people put questions in. So that little round arrow is the refresh button.
you got it.
Okay,
All
there you
right.
go.
Well, I'm going to start with the first one, even though the next one has 6. What about fines previously imposed and unpaid? Absolutely have given it no thought, but it wasn't the law at the time they were imposed. Um, so I think, I think you try and kind of follow through with it. Um, the statute doesn't say retroactively, but boy, if I was a judge, if I was a attorney for a defendant, for an owner being fined, I'd sure show up with it really quick. I don't know how it's going to play. It just, sorry, it's just not clear. Parking violations. Instead of a $100 fine, the HOA communicated via preferred method versus mail. Is it the case that the annual policy statement can be communicated via a preferred delivery method versus mail? I don't know. I'd have to roll back and look at the old statute. The answer is that what the person's touching on is that this year or last year, the legislature passed a law that said that they could enter an agreement with the association, wherein the association communicated with them electronically, so using email, and that's done in combination with Corporations Code Section 20 by the owner to the annual policy state or within the annual policy statement made to the association. So I think we can get there. I think the country, the state is moving that way. I think particularly as we're starting electronic voting. The old reason that we said you couldn't do it was because we have to vote using paper ballots. But now that we're moving to electronic voting, I think we probably could go to an entirely electronic matter. We're doing it with our commercial associations. We haven't done it yet with our residential associations.
So Mark, Warren, hit the refresh button, but Warren Forrest has 10 people that want this question answered. Regarding parking violations, instead of $100 fine, can they do the HOA tows? Any analysis on that one? What do you
You
think?
bet. You bet. You put the proper notices out there. You work with a competent HOA towing company, and I'm serious about that. The HOA towing companies will know the laws, towing laws as they pertain. I'm trying to 22,658 of the vehicle code is the code that you're trying to work with. And if the tow company is familiar with that, you can impose a tow policy. And yeah, absolutely. So get rid of your warnings and your fines and just start towing. Now, listen, don't do that tomorrow. Put out a lot of notice to people. Be very clear to people that you're going to start towing, because if people aren't used to it, you're going to end up having your board recalled if you start suddenly towing 30 cars a night. You're just gonna end up losing the ship. So you need to kind of bring people to the stage. But absolutely, and this is the sad thing about this statute. The sad thing about the statute was fines gave a gradual escalation, and now we have little escalation, but towing and suing, and it's a sad state of affairs. Late charges aren't fines for late payment. No, in fact, it's outside of the collections statute. HOA seek injunctive relief to correct. I thought I turned my phone off. I very much apologize. HOA seek injunctive relief to correct a violation or damages if they don't comply. Yeah, that's right. So remember, under the civil code, if you hope to collect prevailing parties fees as an HOA, you want to first offer ADR. So you need to check that box. I'm going to tell you to offer IDR too. I think I just offer it. Try to fish hook. Try to catch somebody. Get them in. Get them talking. Communication really will cut your legal fees down. So absolutely. Instead of a fine, can the board still suspend privileges like use of a pool or parking? Yeah. The statute, as you saw, only pertains to fines. It doesn't talk about taking away privileges like pools or parking. And that's a great thing for me to remember, because I was like, man, that's 22,658. There we go. So thanks, Ray.
So
Uh,
Mark Sherry Tyndall has got 11 upvotes, and so if we can go to that question.
oh boy, my thing moved. There we go.
Yeah, how does this affect unauthorized modifications, violations when the owner make changes without prior approval according to the policies? Are they also capped?
Yeah,
Example,
I think so.
yeah.
This is a rule, right? Or a CC&R restriction, but it functions like a fine. And so the answer is you're going to cap that at $100, and you're going to go, use that as an opportunity to communicate. So again, you haven't lost your violation protocol. You're still going to send that first letter that said, "Hey, you need to fill out an architectural application." You can then fine. It's going to be $100 unless the board can determine that the thing that the people did to improve the property is a health or safety problem. So maybe if what they did to improve the property was open up the back wall, and now we have an attractive nuisance in form of a swimming pool in the backyard, I think in that situation you can bump up the fines, right?
Mhm.
So,
Can you force them to cure? If they put in, say, a gate and you told them they weren't supposed to, you fined them and they still put the gate in, they paid their $100. Can you force them to remove it?
well, you can't, but a judge can. So essentially, the association goes through ADR, then files a lawsuit, and then the judge makes a
Okay,
determination whether the architectural committee's determination is reasonable.
perfect. Okay, thank
Yeah,
you.
yeah. So Richard Hale, winner, by what date does an HOA have to change its rules and procedures? Now, yesterday, last week, we got so much notice. No, we all learned about this last week, and that's why it was so important to me to reach out to David. I reached out to the other folks in charge of our industries and said, "Hey, are you aware of this? Let's get something because this is California law now." And It's a pretty black eye on the legislature. I'm really shocked
Well,
that they did it.
Vicky Harvey has got a really popular question here. 17 upvotes. Won't homeowners just pay the $100 and keep behaving badly?
I
What
think
can
I
board of
love
directors
that.
do?
I love that.
That's great.
I mean, I have a boat, and the boat, it stays at my house the week before I go places and the week after I go places because we unpack and then the boat goes to the storage yard. And I get fined and I just pay the fine because it's a 4-day fine or whatever. But now it's only $100. I can just leave the boat out in my front yard, right? I mean, there's no need to use the storage facility anymore. Well, the answer is the boat's still a violation of the CCNRs. So you're gonna fine them the $100. You're gonna fine me the $100, and I'm gonna laugh and pay it. And then you're gonna bring me in for ADR, and then you're gonna say, "Hey, Mark, the next time you do it, we're gonna sue you." I'm going to say over a boat, you know, and then we're going to get into reasonableness, right? I mean, because a judge is ultimately going to make that decision. Was this lawsuit reasonable? Um, thank
Okay.
you, thank you, legislature.
Patricia Lynch is next. She has 8 upvotes. If an owner keeps pets in his or her unit in violation of the CCNRs, can we charge them $100 per day for every day they keep them in the unit after we provide them notice and have had a required internal hearing?
Right. Yeah. So let me ask you, Vicky.
Or Patricia, it's
Let
Patricia.
me ask you, Patricia. Is it a violation? Sure. Is
It's a
is
violation per each animal.
Is it a new violation each day? Is it a violation per animal? You know, and again, I think if you're in small claims court, I think you go all out and you let the small claims judge make that determination. But I think that if you're in superior court, I think you want to be a little more judicious about how you're doing that, or you want to pair it with something else like, an assessment collection. Somebody didn't pay their HOA dues. Now you've got a prevailing lawsuit, and then you're going to throw those fines on top of that for something else. It's just got to ultimately in this situation, you're going to go to court and you're going to say, "Hey, judge, this is a nuisance, and I need you to stop it. It's a violation of the CCNRs, and I need you to stop it." And so there's going to be an interesting dynamic, which I do think the designers of this legislation intended, which is, hey, we're going to let the associations charge for $100 fine for associations really got to come out of pocket. So they're going to be a little more judicious in the fines that they assign. I do think there was some design to that. Um, so Patricia, I don't know. Our HOA has a moving fee to protect against damage from moving and to pay the cost of hanging up protective curtains in the elevator. Is that a fine? No, I do not think that's a fine. I think it's just a cost to protect the facility. And your CCNRs require 15 days notice, which just use the longer. Yeah, just use the longer.
Hit your refresh button there, Mark. The anonymous attendee has 9 upvotes here, and it says we are a 55 plus community. So if someone moves their 20-year-old daughter in, it's basically $100 a one-time fine, and we just have to allow her to stay because the financial penalty was the only teeth we had.
Good. So I think people are forgetting, that you start with a standard violation letter, right? You do a fine, you give the notice, you bring them in for a hearing, you fine for $100. And at that point, then you're bringing them in for an ADR, and then you're going to start a legal process, right? I mean, it's the description that you're giving is a pretty clear cut violation of Civil Code 51. And, we're all they did was take away your ability to find higher. They didn't take away your ability to enforce your CCNRs. So
Okay.
it may be the Full Employment for Attorneys Act,
Yeah.
but the association hasn't lost its ability to enforce.
Yeah, this isn't a very good law. I mean, honestly, we need to work on it. So anonymous attendee
Well,
says
I
here,
mean, Dave, I mean, my real question is what I think this was a tester. And I think the question is, what happens when next year they lob in a law that says HOAs can't collect assessments? What are we going to do then? It's law over 24 hours and suddenly everybody's defunded. I mean, this is a dangerous tool.
yeah,
Um, now we have some idiot in the legislature who has behind him on a flag defund HOAs. Every 8 years, the California legislature gets itself together and foments some sort of defund HOA laws. And we, as an industry, go to the League of California Cities and we say, hey, League of California Cities, if that succeeds, all these HOAs in your city are going to be your responsibility to operate. And the League of California Cities comes back and goes, okay, we'll take care of it. And the law goes away, or the proposed law goes away. How are we going to handle something that passes overnight? It's a disaster. Can a
yeah.
board simply line through any fine in excess of $100 and note $100 on the recently approved enforcement schedule, then redistribute it to the membership? I think you could, right? I think you could, because really all you're doing is complying with the statute. But I think you're walking away from opportunities. There is a carve out in the statute for situations where there's life safety danger and it affects neighboring homes, and a larger fine is appropriate, even as admitted by these village idiots who made this legislation. So you could, and I don't think you have to go through the 28-day if that's what you're asking. But I think that I think you're missing some teeth. You're taking some teeth away from yourself that weren't taken away.
So this law is in effect now because it's a was emergency legislation, so it's signed and done, and so we're stuck with it. So that's a good thing. What about those fines those and maybe I missed this that were done before the signature?
That was the first question you gave, and my first answer was, gosh, I think that was under the old law. But like I said, if I'm the attorney hired by the member, and we don't represent very many members, but we do occasionally, I'm going to go in and hold this up and say, hey, judge, this is really the intent in the legislature. This is
Yeah.
what the legislature thinks is fair and reasonable. I think this
Okay,
is
well, Theo has a good question. Theo's been with us a long time, and he asks good questions. So, with
with
reference
reference.
with reference to your example of dog feces cleanup, can we just charge the offending party the additional cost instead of doing a fine?
That's a good one, Theo. So yeah, I mean, I think you can because I think it's damage to the common area, right? And I think that falls with outside of the fine. So if you've got, the poop cleanup crew, that a lot of people do, a lot of associations do, they have a separate fee that they pay their landscaper, or they have a separate fee that they pay a crew, the guys who restock those green stands, where you get the baggies and that kind of stuff.
Yeah, right.
That those guys have to have a charge, and they have to be telling you what the charge is if they have to come out. And I think that's a fair thing to do. Yeah, I do.
Okay. So Anonymous is next with 10. Uh, Monetary charges are reimbursements for cost to the association. Can this reimbursement include the cost of managing the repair? And I think you just answered that, didn't you?
No, I didn't. So this is a this comes in many different areas, like when units burn down, within the unit and that kind of stuff. And the property manager, the HOA manager, is thrust into the responsible position of contacting the insurers and meeting the people who make judgments on how much money the adjusters and that kind of stuff. And I do think that many, usually in Exhibit A of the contract between the managers and the association, there is a charge for that on an hourly basis. So now the question is that administrative cost, can we move that forward? And I want to discern here or distinguish two scenarios. I think when you're talking about damage to the common area, I do think you can add some sort of administrative cost to the manager. If the manager kept track of that cost and it cost the association X dollars more to administrate a repair to the common area, I think that absolutely can be added. The statute indicates there's language in the statute indicating it can. I think if you said HOA manager every time they write a violation letter, that's a $50 fee. So we're going to charge $100 for the fine plus $50 for the manager writing that fee. I don't think that's going to float. I think they're going to look at the language of the statute and shoot it down.
Okay.
Ray Fowler, is that where we're at?
We're at Christopher Fischel.
I gotta
The,
scroll up.
that's the next one.
Why don't you read it to me?
Oh, hold it. No, you're right. You're right. I'm sorry. Anonymous attendee, eight upvotes.
What about throwing food over the back fence to feed wildlife when there is a community problem with rodents, health and safety issue? Yeah, I gave that one earlier as an example. I think it is because what happens is people feed the rodents over the hill, and then little Sally is sitting in the association's common area, and the raccoon comes up and bites her hand because those animals are trained that this is a place to get food. So I do think I think that's a pretty easy argument to make.
Okay. Jeremy, do you want to take his? That's a kind of a long question.
Does the board need to make a written finding every time they actually issue a fine for a major violation? Yes, to an individual. For example, once Alice wants to fine Bob, etc. Or can the board issue a written finding once per listed major violation schedule, and then further written findings aren't necessary each time? I think this is where early on I said that as a company, we looked at should we be looking at the association's individual fines and identifying whether or not it's a health and safety issue. And we ultimately determined that the legislature seems to want the board to make that determination based on the facts and circumstances of each situation. And I'll just give you, I'll give you an example. Off a leash can be a health and safety issue if that dog has a history of biting people, right? If the dog has a history of biting people, then that's a health and safety issue. On the other hand, if it's my 8-pound poodle who's going to go yap and get a pet and try and get a treat off you, it's not. Well, it's the same rule. And so I do think it's got to be kind of made individually.
So Mark, why don't we take two more questions and we can get moving on and refresh. And I have Jeremy. Whoops. Okay. I have Jeremy at the top here. Hold on.
I keep scrolling to the top as well.
I have an anonymous attendee.
Got 7 responses there, Dave.
Yeah. Go ahead.
Correct violation, architectural landscape rather than just apply a fine. Can the HOA seek injunctive relief to correct a violation or damages if they don't comply? And the answer is yes to both, right? When somebody damages the common area, we can get money to make those repairs. We can sue to get an owner to maintain their property. Generally, that lawsuit is done in the alternative. So what we say to the court is, give me a judgment. So I'll submit a judgment for the judge to sign that says either Zapponi has to build the wall between the pool and the public street by the 3rd of July or August, or in the alternative, the association can come in and do that. If the association does that, they have 3 bids and they're going to use the middle bid to get it done, and Dave's going to be responsible to pay for that. So that's how we go into the courts. We've learned over the years that we can't just get an injunction asking somebody to do work. We need to have the alternative language that allows us to go in and do it because kind of like people walk through restraining orders, people walk through injunctions and don't do the job. Is smoking considered a health and safety issue? It is.
That's pretty easy. You can go to the next one.
As per our rules, glass bottles in the pool or spa areas. I mean, I think this is gonna be $100 fine, you know? I don't think you're gonna I don't think you're gonna start raising that to 350 and 500, and I don't think you ever were gonna.
Yeah, escalation of costs or fines. How would you do that?
I'm sorry?
Bob Mack, he says, how are escalating fines affected by the ruling?
Yeah, I
Are
think you could do that. You can escalate 25, 50, 75, Bob. That's not a problem. It just says they're not supposed to exceed 100. I guess the argument would be that at some point you're at 150, right? 25 plus 75 plus 50. You know, let them argue it. I would do it
Okay.
at that dollar level.
Yeah.
So
Go ahead.
are we how many more do you want to do?
Yeah, I think we're good. We should it's really up to you. We are
Well,
at
I'm gonna take it at kind of my closing statements, right?
okay.
And because they're short and because it's sort of important. Like we really encourage you guys to shoot your fine schedule policies, get them adjusted per this law. But it's also a real logical time to work with your attorney to have rules reviewed. And am I recognize that I sometimes welcome criticism that an attorney is telling you to talk to an attorney. I am really conservative with my clients' money, and I think that this is the time to get in, let an attorney give you an addenda, let an attorney look at your rules, let an attorney make sure you're not violating fair housing. Like I said, we're dealing with about 20% of the rules, 1 out of 5 that I see that violate fair housing in some fashion. That lawsuit is way more expensive than this one. So I just think it's time. It's a good opportunity to do it. So there, that was it.
Well, sounds good. I appreciate everything you do, Mark, and for putting this together so quickly. We're gonna go ahead and move on. Just give me 2 seconds here while I get my script up. There it is. And so thank you so much for doing this, Mark. And we don't have a sponsor today, which is a little unusual. Usually we have sponsors, but
There was hardly any time, Dave.
yeah, we hope that we get sponsors in the future. So talk to your particular vendors out there, all of you that are participating today, and maybe you can get them to sponsor one of our sessions. We appreciate that. Mark, Mark and Connor, thank you so much for putting this together. I want to thank I want to say thank you to the Echo members for coming today and supporting our ongoing Echo webinars. For those of you who are not Echo members, please consider becoming a member and supporting HOA boards throughout the country. To join, simply go to www.echo-ca.org and click on the membership tab. For Echo members, thank you for supporting us, and please invite your friends, boards, and especially management firms and vendors to join Echo. A simple invitation is often all it takes to encourage someone to become a member. If you would like to become more involved with Echo, please consider joining our volunteer corps. We have a number of people in the corps now. As part of our volunteers, you will have a few opportunities where we could use some help. Please refer to the slide. If you see anything that looks particularly interesting, please let us know. You can send me an email at dzapponi@echo-ca.org and we can talk. Now, for the other announcements that we have, Echo HOA University has an educational program focused on HOA board preparedness. Our core curriculum of 10 courses is designed for high quality training and is available for HOA board members, interested homeowners, and professionals. Your participation in this program will earn you a certificate of HOA board member preparedness. The courses are offered online live, and most courses are recorded and are available on demand. If you or someone you know wants to enroll in a certification program, please send us an email at Connor, and his email address should be on the screen. So send it to Connor at echo-ca.org. He'll set you up, and his email's on the screen. As we move into the summer, actually, we're halfway through. Here's a preview of some of the resource panels coming up and starting in August. Sacramento Resource Panel is Tuesday, August 5th. Landscaping is the topic. The Echo Club at Rossmore, TCAR, is Wednesday, August 6th. The topic is budgeting and reserve studies. That's in Walnut Creek. The East Bay Resource, and anyone's can attend that meeting. We just need to know that you're registered. East Bay Resource Panel, Thursday, August 7th. The topic is budget season toolbox. Los Angeles, down here, we have a meeting on Tuesday, August 12th. The topic being preparing for the budget season. I think there's a theme here, right? Orange County Resource Panel meets in Laguna Hills on August 13th, and the topic is reserve studies. San Diego Resource Panel will meet August 14th, and that one is about how to prepare for a roofing project. These are in-person meetings. The resource panels are all in-person meetings. We also have two larger events that are coming up and planned for this year. One is in Southern California in Laguna Hills on October 10th, and it'll be multiple speakers at that event. And then we have a legislative update and NorCal seminar on November 15th in Walnut Creek at the Rossmore Event Center. Thank you to Mark for providing information on this important change in the legislation. And of course, thank you to all of you for attending today and making this a successful event. Echo appreciates your investment in education to foster a better quality of life in HOA communities.